Nobody knows that. Nobody knows that when is a husband and wife and one of them dies. They all come to my office and say, but we're married. I didn't have to probate that. It was mine, right? I get it. No, that's not right. You need to know what the law is in your state about that. If it's a tenancy in common in most states, that creates a 50% undivided interest that has to be probated through the estate of the deceased owner. And most people don't get that. A joint tenancy with right of survivorship, on the other hand, creates a joint form of ownership where the surviving tenant or tenants gets title to the property upon the death of one of them. And that is a form of ownership that helps with estate planning to avoid having to go through probate. And that is something that we're going to talk about extensively after our break, is estate planning and probate and those things that we can do to help eliminate the need for probate and keep the cost of probate administration down. We do an awful lot of these joint tenancies deeds because attorneys, real estate attorneys, will, two people are buying it, you get it as tenants in common unless you ask otherwise. If you don't know to ask otherwise, that's what you got. So if it says to John Doe and Jane Doe, that's a tenancy in common. Each of you gets 50% interest in it. When you come to see me to do estate planning, I say, do you have a joint tenancy deed or a tenancy in common? And you say, well, I don't know. I think it's a joint tenancy, right? And no, it's not right usually. Bring me the deed and we'll look at it. We can redo the deed. We can convey it from you as tenants in common to you as joint tenants with right of survivorship. And then in some states, like Florida, for example, there is what's called a tenancy by the entirety. So if you own property, a husband and wife owns property, at the death of one of them, it automatically goes to the other one. Each is assumed to have a 100% undivided interest in it, severed by divorce. So if you get divorced, then you end up as tenants in common. But in those states that have tenancy by the entirety, that clarifies our issue about whether we own it as joint tenants with right of survivorship or tenants in common if we're married to each other. And we talked about differences from state to state. Please go home and review your deed. If you think that you and your spouse own this property and there's a joint tenancy with right of survivorship and that you're going to get it when your husband or wife dies, and make sure that that's the case, if that's what you think it is. If it's not the case, have the deed redone, redrafted. There is a difference between insurable title and marketable title. And the difference is that a title insurance company will cover some hazards and some defects in title that that might not be acceptable to someone looking for marketable title. If you recall, in South Carolina and perhaps in some other states too, there was a claim by the Catawba Indian tribe for violation of a treaty, and they claimed all of York County. So at that point, the title insurance company came in and settled those issues, either by helping those people to claim their property by adverse possession or paying the Catawba or doing something to make sure that those defects were cleared up. Title insurance covers defects that are undiscoverable from the public record. So if we go down to the courthouse and everything looks just peachy with our title, but there happens to be a sewer line running underneath a swimming pool, and the sewer line has to be dug up, that swimming pool has to be removed, title insurance will come in and take care of that. Title insurance is generally required if there's a loan obtained on the property. An owner's policy that covers the equity interest can be obtained at the same time for a very small additional fee. And it can be obtained at any time. If you don't have title insurance, generally it is for structures, houses on lots, rather than open land. But you may want to ask your attorney or your title company whether you can obtain title insurance coverage for your property. Title insurance does not cover any discoverable defects. So if you know about a defect on there, if there's something recorded that tells you that there is a problem, you need to have that cleared up. This is only for undiscoverable defects. So how do we know whose name the property is in? We need to look and see if there's a will, if there was an intestacy. We need to know how we got that property. And the intestacy statute says who got it if somebody died and owned the property. So the intestacy statute of the place in which you sit may be the one that is applied. It may be the intestacy statute of the place where the land sits. So if you're Anna Nicole Smith, you have a Florida property and a Florida cause of action. You have something in the Bahamas. You have something in California. We don't know which intestacy statute is going to be applied to figure out who got that property if it's determined her will is invalid. If the decedent was married with no children, generally the spouse takes everything. In some states that's different. You need to check your state's intestacy statute. If there are children, generally the spouse and the children share the property, and that can be a nightmare if there are minor children who get a portion of that property, particularly if they're minor children from another marriage and you have the second spouse owning property with the minor children from this first marriage. Your family structure. If you don't own the property but you inherited it along with others, if your name is not on the deed, you need to do something. If you do not have a deed with your name on it or an order from a probate court that says that you own it, you need to do something now, because the longer you wait, the bigger the problem's going to get and the more expensive. If you need to acquire title to the property, you may have to bring a legal action to do that. And you have to be prepared to buy out or bargain with all of these other heirs, because the minute they discover they have 1/362nd interest in this property, they're going to want some money. So you got to be prepared to negotiate with these people. Marketable title is title that is free from any reasonable doubt, and that may be the kind of title that is required if you are entering into a contract to sell your property. Good and marketable title. If your title's not marketable because there's a defect in it, then that person who has agreed to buy your property may be able to get out. And being able to void that contract of sale can end up in years of litigation to try to straighten out that problem. So identify who owns your property, how you got it, what you need to do to make sure that you have cured any defects, that you are aware of any easements, that you have given permission for any unintended use of your property, or you have put up a fence or a gate to block access. You can do that as well. Make sure that you understand the character of your property, where the lines are on the ground, what you own, where the property boundaries are, and how to determine where those are. Also need to make sure that you know whether you have joint ownership that is a joint tenancy with right of survivorship, a tenancy by the entirety, a tenancy in common, and who owns what, because that's going to be important when somebody passes away. And the last thing you need when you are dealing with someone passing away unexpectedly is to try to deal with the question of whether I got the property or whether it went to somebody else. You know, what happened to it? I get people in that have property issues all the time. I had a lady the other day who told me, came in with her sister-in-law, and she said, well, she owns the property. And I said, but it has somebody else's name on it. And she said, yeah, it was in my husband's name, but I didn't include it in his probate estate because he shouldn't have had it. So he shouldn't have had it is not legal title. It's not a legal conveyance of title. If you've been dead more than 10 years in this state, you have to bring a legal action to determine heirs, and you have to send out all kinds of certified letters, return receipt requested, and get appointments of a guardian ad litem for anybody who's unborn or minor and who you might not even know about. So you want to make sure that you have a clear understanding of exactly what you own, what you don't own, what interest you have in what you do own, and that you are comfortable with both the type of ownership you have, the legal description of the property, the assessor's description of the property, your tax treatment of the property, and that you are good to go to the next step, which we're going to talk about after the break, which is estate planning.